Good day. Today we are going to do lesson 3, dealing with international environmental law. For the agenda, we are going to look at the history and development of international environmental law, the sources and principles of international environmental law, and the important environmental law treaties that are there. And then we are going to look at what happens in international environmental harm when one country um, causes environmental harm in another country. Transboundary pollution. What happens in that regard? We're going to deal with that. And then the rights and duties of states at international law. We're going to look at certain principles that are founding on those rights and responsibilities. Now, in terms of historical development, the history of international environmental law can be divided into 3 stages, separated by 2 of the most relevant international conferences held so far. We have the Stockholm Conference as well as the Rio de Janeiro Earth Summit. And then lastly, we'll look at the signing of the Paris Agreement, a new stage which began to confront humanity's most important natural challenge, which is the climate challenge that is before us today. Now, before the 1960s, there was little environmental awareness. Only a few isolated international environmental regulatory initiatives were there. One of those was the failed London Convention of 1900s, the convention which sought to protect African wildlife. It never came into force because it was not signed by the minimum number of parties that were supposed to sign it. It was replaced 33 years later by the 1933 London Convention, which was implemented in much of the colonialized African countries through the creation of national parks and species protection. Now, after the 1960s, we came the Stockholm Conference. This is a product of the first UN conference on the human environment, the Stockholm Declaration. This was the first international document to recognize the right to environmental health through setting out 26 principles, many of which have played an important role in subsequent development of international environmental laws. Also, it is the Stockholm that created the United Nations Environmental Programme, and which is now the central body in charge of environmental affairs. Now, after the Stockholm conference or declaration, the most pivotal place in history now came in with Rio de Janeiro, the Earth Summit. It became central in environmental awareness internationally. It is in 1992, during this conference, 2 conventions were presented to be signed by the national governments: the Convention on Biological Diversity and Convention on Climate Change. The Rio de Janeiro was established, the Rio Declaration, was established, which affirmed the Stockholm Declaration and the Agenda 21 Action Programme, which continues to govern governments and non-state actors in environmental protection today. In Rio, in the face of growing evidence that human actions in trying to achieve economic growth were responsible for major environmental harm, the central concept there was to ensure sustainable development. So we talked about this during class, and I was saying that the Stockholm Declaration, it gave a framework. This where they understood now the concept of environmental protection and so forth. But it is in the Rio de Janeiro, the Earth Summit, wherein they were now giving flesh to the right that they first recognized in the Stockholm Declaration. They're now giving it flesh by recognizing the need for biodiversity, the aspect of climate change. Now, the 2 principles of the Rio Declaration deserves special consideration. The precautionary principle, which is the most advanced form of prevention, and it is important to the formation of the modern international environmental law. Principle 10, which recognizes the right to information, participation, and justice in environmental matters. In 1998, Principle 10 gave rise to the Aarhus Convention binding in European and Central Asia, and it is this convention which is the predecessor of the Escazú Agreement, which seeks recognition of these rights in Latin America. Now, in 1993, the UN created the World Convention of Environment and Development, known as the Brundtland Commission. Its work, which focused on the difficult relationship between environment and development, resulted in a report called the Our Common Future Report. And that report was the report that coined the concept of sustainable development. It defines sustainable development as meeting the needs of the present generation without compromising the ability of future generations to meet their own needs. So it is from the Earth Summit up until the convention that we just talked about now. We now see a revolutionized concept of environmental protection, which is a concept centered on sustainable development. Now, linking the Paris Agreement, Kyoto Protocol to address climate change gave way to the Paris Agreement. The Kyoto Protocol gave way to the Paris Agreement in 2016. In this agreement, signatory parties or countries came in to try and prevent the average temperature of the climate from rising by 2%. Now they're trying to tackle um, climate change. They're trying to tackle the level of greenhouse gas emissions. So from these three agreements and conferences that we just discussed, we see a development in international environmental protection. From first the Stockholm Declaration, which gave the skeleton for environmental protection, and then we have the Earth Summit, who came in and gave the flesh for environmental protection. More specifically, I was dealing with biodiversity, climate change, and then we now have Paris Agreement. We have done all that. We have signed what we want to sign. We agree we want to achieve environmental protection. Now it is through the Paris Agreement that they're taking action in the implementation of environmental protection through ensuring that they do not the greenhouse gas emission of the planet do not rise above 2%. So having been ratified by almost all countries in the world, it has immense potential as an instrument for international law. So Paris Agreement comes in to try and enforce environmental protection. Now, sources of international environmental law. Why are these important? Well, we'll see that there are different sources that created international environmental law. Before we look at the content, let's look at where this content came from. And it is from those sources that we also see how they try to enforce international environmental law and whether they are effective in those trials, and whether the factors behind those sources make it ineffective for nations to really enforce environmental law. Now, the sources for international environmental law range from treaties, international customs, general principles, judicial decisions, and the works of jurists. Now, in terms of treaties, we discussed this in class. Most of us are well aware that from our international law background, that the different treaties that are the multilateral treaties, contractual treaties, legislative treaties, constitutional treaties. Um, which are binding on states who agree to be bound by those treaties. An example of contractual treaties would be treaties relating to trade and extraditions and so forth. So this is where we get a source for international environmental law, wherein states agree we're going to do this and this to ensure that the environment is protected. So treaties are not the only one. There is custom. This custom, it is common law of the international community, and for a law of or for a norm or practice to be referred to as a custom, it has to meet two requirements. It has to be a settled practice and it has to be accepted. And it has to be accepted and binding on the states. So this is custom. Generally, as we discussed in class, most of these sources, we have already dealt with them under international law. So I will not go into detail per se. Now, besides treaties and customs, we have general principles and judicial decisions. Now, when treaty and custom cannot be drawn upon, common principles of law found in municipal systems can be used in order to fill in the gaps. For example, um, principles which stretch from unjust enrichment and estoppel principles that really are common on most nations and they apply internationally. And then we have judicial decisions, and according to Article 59 of the ICJ, provides that the decision of the court has no binding effect except between the parties and in respect of that particular case. Thus, they're just merely persuasive on other nations. So this statement is saying that when a decision has been made between a disagreement between two states, the decision, when it has been made by the ICJ, it is only binding on those two states. You'll find that for international environmental law, we have a lot of court decision about the different transboundary environmental pollutions that have happened. Now, what is the effect of that decision on other states who were not part of that conflict? Well, it is not binding on other states. It is merely persuasive in nature. Now, there are other sources as well, like soft law and juristic work. Soft law, codes of practice, recommendations, guidelines, declarations, which do not fit neatly into the categories of the legal sources that are referred to. So these mostly resolutions from conferences and recommendations and guidelines set out by international organizations and from international conferences. These are soft law and they are of persuasive nature, and unlike the judicial decisions, they're merely persuasive in nature. And then we have juristic work. They have no authority but merely throw light on existing rules. If you want existing rules to be further explained or to be understood, we look at juristic work so that we understand what that international environmental law is trying to say. Now, in terms of enforcement of international law, as we were discussing the sources, you could see that enforcement is really hard because most international laws are just merely persuasive in nature. They are not binding on different states. So it is really hard to enforce not only just international law, but also international environmental law. Now, as you can clearly see from the slide, it is written enforcement of international law. So generally, international law is enforced through economic sanctions and the use of force by the United Security Council. As you see from other states, from other cases, from the case law that we'll look at, like the Tetro Shroom case and so forth, there are some embargoes that were used by the United States to try and force environmental protection and so forth, it did not go so well, but they tried, and those are the various mechanisms or enforcement mechanisms that have been tried before to try and enforce international environmental protection. Now, application of international law in Zimbabwe. We have talked about international environmental law. How does it relate to us? You might ask yourself, okay, what does all those sources and international environmental law have to do with Zimbabwe? Well, there are provisions within our constitution which bridge the gap between international and national law. And those provisions are listed there on your slide. It says that Section 34 looks at the fact that the state must ensure that all international conventions and treaties and agreements to which Zimbabwe is a party to should be incorporated in domestic law. So the domestication of international environmental law ensures that those international environmental laws also apply to Zimbabwean citizens and Zimbabwean people. And also we have 326, which says that customary international law is part of the law of Zimbabwe unless it is inconsistent with this constitution. So here there's an automated interpretation that customary international law, so long as it is not inconsistent with Zimbabwean law, then it is a part of us. We should acknowledge its existence and recognize it. Now, we also have section 46 interpretation of chapter 4. It says that the courts have to consider relevant foreign law when they are making decisions. And we also have section 165, principles guiding the judiciary. It says that the courts must keep themselves abreast of the development in domestic and international law so that they're able to apply those laws in their decisions. Now, in terms of international case law, there are different cases that are there. We discussed those cases and my inability to pronounce the names of the first case, and I just refer to it as the Hungary and Slovakia ICJ case. All these cases that are noted there, they appreciate the need for sustainable development. It is a principle, an international environmental law principle that is also evident in our state today. We see it in our national development strategy, which is for sustainable development with the need to the edge of the country to achieve middle income society and the vision 2030. We are all trying to fasten that need for development, and we are hoping that we do it sustainably while protecting the environment in the same way. Now, all those principles stem from international environmental law. As you can see from these cases, they referred constantly to sustainable development, and also we'll see from regional policies that also look into the need for sustainable development. And all those international environmental laws have made their way to Zimbabwe and have become part of our law. So you will see all throughout our studies that sustainable development has become a central part. All the principles that we will study in international environmental law somewhere somehow circle around this principle of sustainable development. It has become central to those principles. It seems as if it is an advanced version of all those principles that we have been developing thus far. Now, as we continue on, we are looking at provisions within our constitution that bridge the gap between international environmental laws as well as national law. And one of those provisions is a provision that allows the president to get into treaties, and section 327 says that an international treaty which has been conducted and executed by the president does not bind Zimbabwe unless approved by the parliament. So they're just saying that it has to be domesticated first for it to be binding. Now, what are these principles of international environmental law? Now, the principles stem from the various sources of law that we've been talking about. And those principles have made their way into national law. There are some principles that are strictly on an international level, like those principles of state sovereignty, which can really not necessarily be converted into domesticated law, but they need consideration nonetheless. Now, state sovereignty, the principle of state sovereignty and responsibility not to cause environmental harm. This stems from Rio Principle 2 and Principle 21 of Stockholm Declaration. You look into that yourselves. And then stems from the Charles Melter case. Please read up on that case. Wear that case like the skin on your bones. And in such a case of pollution, damages can be claimed by the victim state, but the precautionary principles require taking preventative measures as well. So this is saying that any state that causes environmental harm should take responsibility to remedy that harm. But most importantly, this principle is saying that we should prevent the harm from happening in the first place. Principle of good neighborliness and international cooperation. We see it in Article 7 of the United Nations Charter. We see it in Principle 24 of the Stockholm Declaration. We see it in the Rio Principle 27. And it is also evident in cases of shared resources. It requires prior notification, consultation, and negotiation in activities involving environmental risk. A good neighbor, for example, would tell their neighbor that, I'm about to play this radio, I'm about to do a party which might result in noise pollution, so please be aware, or I'll try to turn the volume down so you are not affected. That is good neighborliness. So in terms of the state aspect of it, nation's aspect of it, this principle is saying the same. If a state is about to enter into activities of environmental risk, they should notify any potentially affected states, consult with them, and negotiate with those activities to reduce any environmental harm. That's what this principle is saying. Then we have the principle of preventative action, which is the Pulp, seen in paragraph 101 of the Pulp Mills case. And then we have the principle of sustainable development, seen also in the Pulp Mills case. Please read up on this case as well. So in the Pulp Mills case, they stress on the need or the interconnectedness between equitable and reasonable utilization of a shared resource and the balance between economic development and environmental protection, right? So we see again the principle of sustainable development coming back again. This principle is also recognized in the WTO. It has been generally accepted as integrating economic and social development and environmental protection. It is also explained in the shrimp turtle case. I explained this case before. This where the U.S. banned the import of shrimps from certain countries in Asia because of legislation that prohibited the imports of shrimps without the sea of turtle excluding device, which prevents turtles from being caught together with the shrimps. So the appellate board decided that this restriction did not meet the requirement of the exhaustible natural resources exclusion, but held that free trade requirement of discrimination had been violated. So the U.S. tried to put trade restrictions or ban the import of shrimps from certain Asian states because they did not agree with the way the turtles were being the way the shrimps were being caught, because when they were catching those shrimps they were also inhumanely affecting the turtles. So as a result, they put sanctions on those Asian states, and the body said that what they had done was against the free trade requirement. Now, as we continue on, we have the polluter pays principles. We see that principle at an international level at the Costa Rica versus Nicaragua case. I explained that case in class. You read up on it. Now, the early development of this principle is merely from the recommendation by the Council of the Organization for Economic Cooperation and Development. This principle acknowledges that environmental resources are scarce and cost of deterioration of the environment and whatnot should be taken into account. And they're saying that when you do cause environmental harm, you have to remedy that environmental harm. This really the polluter pays principle will see its application at a national level on the next chapter. Now, the principle of common but differentiated responsibility. Now, this principle is pregnant with a lot of other interrelated principles. This principle acknowledges that there is environmental injustice. It acknowledges that there is climate injustice. It now acknowledges that there are some people that are being affected by environmental harm more than others, and there are some people who are more responsible or more guilty than others. This principle says that though it acknowledges that states are all responsible to ensure that there is environmental state, it also acknowledges that there are some states who are more developed, which have contributed more harm to the environment and should thus have a greater responsibility to ensure environmental protection. That's what the principle is saying. It is clearly laid out in the Rio Principle 7. You can read it yourself. And then we have, what do these principles that we just stated, how do they affect the the relationship between the environment and trade? Um, we all know about the general rule of free trade governed by the General Agreement on Tariffs and Trade and the World Trade Organization. Um, but despite this general agreement, states like the United States have tried to manipulate their economic power in a way that would ensure environmental protection. It was not only in the shrimp turtle case, but there's also another case, the tuna dolphin case, wherein the state put an embargo on the tuna that was caught in an unfriendly way in another country. And the panel held that the United States could have used less restrictive measures to ensure environmental protection of the dolphins. So we we see how not only judicial decisions have affected environmental protection, but we also see how trade has been used as a tool for environmental protection. We also see how the environment, despite some efforts by some to ensure environmental protection through sanctions and so forth, it is thus far been unsuccessful. Now, environmental impact assessments. This tool, which is now being used also in in our national level is stems from international law. This assessment is a practice which in recent years has gained so much acceptance among the states that it may now be considered a requirement under general international law to undertake environmental impact assessment where there is a risk that the proposed industrial activity may have a significant adverse impact in a transboundary context. Now, so when there is potential in transboundary harm, countries must or should use environmental impact assessments to evaluate the risk of environmental harm and see potential ways to reduce that harm and even remedy it. Right. So this instrument, environmental impact assessment, is now there in Zimbabwe. It comes from international environmental law. We'll discuss it later in other chapters. Now, there are different treaties on international environmental harm. As you can see, there are a lot. Ramsar Convention, CITES, World Heritage Convention, Bonn Convention, Vienna Convention for the Protection of the Ozone Layer, Basel Convention, Bamako Convention, Paris Agreement, Stockholm Convention. All these are trying to ensure environmental protection. Read on these, familiarize yourself with them. If you read a whole treaty once or twice, you will never forget them. Now, as for the CITES Convention, it is an international agreement between governments. Its aim was to ensure that international trade in specimens of wild animals and plants does not threaten their survival. Right? So this is just trying to ensure the protection of endangered species. Right? We see the importance of these international agreements. How? Because even now in Zimbabwe, there's a National Ivory Action Plan. The result of this site is to ensure the protection of endangered species, right? So there are a lot of statistics on how all these treaties, especially the CITES treaties, have made an impact in environmental protection. Please familiarize yourself with those things. So this is international environmental law. Right now you must be thinking, dude, that's a lot, but it really is not. If you dumb it down a bit, you find the summary is just historical and the history and development of IEL is just divided into three. Stockholm Declaration, if you know pre-Stockholm and Stockholm, post-Stockholm, the Rio de Janeiro Earth Summit, if you know the Paris Agreement, you now know the historical development of international environmental law, you're done. And then you look at the sources, treaties, customs, judicial decisions, soft law, you are done. And then in terms of important international treaties, those list Marco Convention, CITES, Stockholm Declaration, and so forth. You are okay. And then we have liability for international environmental harm. We're looking at transboundary pollution. You know the cases that are there, right? That case, the Hungary-Slovakian case, ICJ case, and the cases for what's it? The Costa Rica versus Nicaragua cases. You know what happens when there is international environmental harm and the need for environmental impact assessments beforehand. You know the cases, the principles that are underlining in those cases, in cases of transboundary harm, right? You're done. And then we go on up to the rights and duties of states. We look at the principle of good neighborliness and the state sovereignty, principle of common but differentiated responsibility, all those things. And then you are done. That was just the whole chapter. So familiarize yourself with this and you become an expert in international environmental law. Thank you.